many of you, I'm sure, have heard that the Kenton County Family Court has broken up with me. After my unsuccessful 12 attempts to break up with it. But nonetheless, breaking up is it's not a fun experience. And I think that, it's important to look at the bright side and move on in a positive way. I think we can be friends. I hope to be friends. I hope to contribute to your happiness and success. It's not you, it's me. Nothing wrong with you at all. We just have different interests, just different values. That's all. I believe in equality and following the law, the rule of law. No backroom deals, no ex parte communications, not emailing the court completely inappropriately by private attorneys and having communications with staffers doling out special favors, staffers manipulating the docket for its special friends, and you believe in kind of all those things, and we're just incompatible that way. There's somebody for everybody, and I think it's going to be okay for you. Breaking up is hard to do, and I got your hate note, and look, I understand that there might be hard feelings. I'm glad that you're finally prepared to love me by setting me free, and that's what we do when we love folks. I'm going to miss some things. Sure, I'm going to miss some things. We had special times together. Who can ever forget the magnetic connection that we had? Remember that time when we had a trial and you wouldn't let me introduce any evidence? That was so fun. And what else? Oh, the time that my case was fixed. You fixed my case. That was so joyful. That was really great. Unforgettable times. But ultimately, we have to move on. Remember the time that you let the guardian ad litem refer to my attorney as my girlfriend in court? Remember that? The court-appointed actor? And, it was like rank misogyny and borderline, harassment right in open court. Wasn't that so fun? It probably not as fun for me, but you seem to enjoy it. You certainly let it go on. The hate note that you left me today, it was hurtful. It was hurtful. I don't think that I've been a bully. I don't really understand kind of where you're coming from with that. I mean, after all, you denied fundamental constitutional rights in a court order that is 20-page, single-spaced, written 33% literally by the other side, contains findings of fact that have nothing to do with any of the evidence in the case, begging the question, where in the world did you get that information? And you played and back to the whole case fixing thing. I mean, it was a moment where I think, I determined that we just had different paths. Again, fixing a case is a big thing, and that's an irreconcilable difference that we have. I didn't, I don't want any trouble for you. I wish for you your happiness. I wish for you your blossoming in this new chapter of your life. And I hope that chapter happens. I really don't think that I've been much of a bully. I've been kind of insistent that you not violate me and my family. I don't think that that's being a bully. But we can agree to disagree on that one, okay? And I threatened you. I don't know that that's a loaded word there. If by that you mean like Did I threaten? Did I speak forcefully when I caught a court staffer and a private attorney doing a backroom deal that, if not caught, would have resulted in, basically a court staffer playing judge and giving relief that the court ultimately denied and was not entitled to, was not entitled to be given under law? Did I have to parent that situation? I did. I put the entire thing on Facebook, and it seems to me, from anybody I've talked to, the bigger point there is not my threat to catch you, but the fact that I caught you, what you were doing. I don't know that so many people are interested in really how I spoke to you when I caught you robbing the public trust. There seems to be greater interest in the fact that the public trust was being robbed there, and that is right there in the email, on Facebook. That's bad. So that's bad. That didn't help our relationship. It didn't help. It didn't. So I'm not the hate note kind of guy. I understand that you are. Your friends probably, I don't really, the guardian ad litem guy, and I calling my girlfriend or my lawyer my girlfriend in open court, being dismissive of her in that way on the open record. I'm not into misogyny and harassment, and I think that the Children's Law Center may need to do a little better on its sexual harassment training and inclusion policies, but those are your friends, not mine. And it just didn't work out that way. So, I think we can just agree to move on. If you need anything, I'm here for you. Speaking of which, one thing I might be helpful with is if you have questions about the law. Again, the hate note, I pointed this out before and it doesn't seem to really catch, but the legal standard is not whether you yourself think, court, that you can be impartial. It may not surprise you that pretty much everybody thinks that they can be impartial. So that's not how the law accounts for it. The standard is whether a reasonable third party would think that, would have reason to question your impartiality. And I think we hit that point about 12 motions for disqualification ago. But that's the kind of thing I could be helpful with. A lot of your orders sanctioned me pursuant to case law that's been repealed. Trust me on this, that's not a good look there. We do have the 19 things on the Court of Appeals that have to be kind of resolved, and it's out of my hands about the whole case fixing thing. That's a really big deal, and I wasn't going to mention that, but since we're having the exit talk here, somebody's going to have to justify how you wrote a 20-page single-spaced opinion in a day after reading 30 pages of briefs, considering evidence cited therein, and parties' legal arguments. And unless you can do that, that is not good, because it means that my case was fixed. Also, the attorney, told my attorney that it was. Generally, these are things that get in the way of good relationships. And I just, I care about you, but call me if you need help with the law. I almost offered before, it didn't seem appropriate, but if I was going to be sanctioned, I would like to have the orders not have grammatical mistakes and just actually reflect current legally valid law. And I was going to offer to help with that. Katie didn't think that was a great idea. It was going to be taken the wrong way. But call me. Legal research and stuff like that doesn't seem to be kind of the thing that you're interested into. And, it's kind of one of my things. I can help with that. Gardening, legal research. If you need, look, I'm here for you, and I know there's hard feelings, but you're going to be okay. You're going to be okay. All right, then. Well, you have some things that belong to me, like my 14-year-old daughter that you took a year ago, and completely in violation of the law. It was in violation of the law then. It's in violation of the law now. There's a book, and if you read it, it's called the Statutes. I know. I'll try and stick to the monosymbolic, but there's a little thing in there that says the court shall not unless, and then there's another report that's been sitting at the court for a long time. It's kind of backed up because we had to have a 4-hour hearing about the attorney getting paid pursuant to legal authority that doesn't exist, and when the law says that's not allowed either. But that kind of usurped the time that I think we could have spent on, like, again, the law says kind of. So if I can get my daughter, that'd be great. If I can have my constitutional rights back in respect to the other case, in the case where I was fixed, no hurry, would be great. Okay. Hey, I enjoyed it. I did. Okay then. All right.